the Appellate Division Court Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near and their defendant shall be heard.
Thank you. Please be seated. The first case on for argument today is People v. Laws, case 602. Counsel, can you hear us?
I can, Judge.
Very good. We can hear you. Please proceed.
Good morning, Your Honors, and may it please the court, Peter Banishak for Mr. Laws. I'd like to address the first 2 points in the brief this morning, starting with point 1. The lower court here committed a mode of proceedings error when it found a fact and instructed the jury that it was Mr. Laws who requested that the fingerprints police found at the bank be compared to the fingerprints of a third-party suspect. In so doing, the lower court usurped the fact-finding power of the jury and denied Mr. Laws his fundamental right to a trial by jury. The Court of Appeals has made clear that such errors constitute mode of proceedings errors that require reversal, even absent preservation and even absent prejudice. In this case, however, of course, the error was preserved by multiple objections by Mr. Laws. Respondent's brief primarily relies on the contention that Mr. Laws had previously stipulated to these facts by making statements during his opening statement. I respectfully submit that the statement Mr. Laws made during his opening statement was essentially pressed to do so by the court as an initial matter. But regardless of that, the lower court specifically instructed the jury that any statements made during the opening statement are not evidence, and respondent's brief does not cite to any authority standing for the proposition that a statement made during an opening statement can constitute a factual stipulation. As a result, the claim that there was a waiver here is based on a faulty premise of Mr. Laws having initially agreed to some sort of a stipulation. I would also respectfully note that any waiver would be ineffectual under the circumstances of this case in light of the requirement found in the New York Constitution that any waiver of the right to a jury trial and even a partial waiver must be done in writing and in open court. We have no writing here and therefore no valid waiver. The respondent's brief primarily also relies on the First Department's decision in People v. Hill, which it argues is directly on point. However, in Hill, the trial court informed the jury of a legal ruling it had previously made. It did not instruct the jury that a particular fact is true, and as a result, that case is materially distinguishable. I haven't found a case, nor does the respondent's brief cite a case where a trial court has instructed the jury on a fact after finding a fact on its own. Instead, the typical process is such as was found in People v. McDuffie that we cite in our brief, where the litigant who is opposing a particular factual issue is given the opportunity to rebut that factual issue on redirect examination, even if it's through inadmissible evidence that somebody has opened the door to. That should have been done in this case. And I think it's also worth noting respectfully that on cross-examination, Mr. Laws was not actively introducing misleading facts. The facts that he was introducing were correct, that it was the prosecution who requested that the fingerprints be examined. However, that was only a partial recitation of the facts.
Mr. Banaszak, but getting back to the other point that you mentioned, this came out during the opening statement. I mean, the defendant representing himself pro se, made this point to the jury and said, no, I asked the DA to do it. Do I have the fact correct that it came out during that time?
He did say that. However, he said it after the trial court specifically said it should be clear that you're the one that initiated the fingerprint. After the court made that directive, Mr. Laws did say that. But again, regardless of whether he said it, our position is that that does not constitute a stipulation generally, and certainly not under the facts of this case.
But theoretically, one could suppose that the court did your client a favor, because the jury might be sitting there thinking, wait a second, you told me in your opening statement that you're the one to ask for it, now you're blaming the DA. So by the virtue of the lack of that clarification, your client's credibility could well have been hurt. At least that's my read of the record. Do you disagree?
I do disagree in that, again, on cross-examination, Mr. Laws was not introducing facts that were directly contradicting this idea that he had made the initial request. I think he was making the point that that ultimately the DA's office did in fact convey that request to the fingerprint examiner. That's the only thing that he was conveying at that point, and the prosecutor objected, essentially anticipating that Mr. Laws would be making a further argument, which very well may be true, but that at that point he had not yet introduced facts or attempted to introduce facts that were contrary to that, and instead the lower court again made a factual finding and instructed the jury on that fact. And regardless of whether the court was doing him a favor or whether it can be interpreted that way, the fact of the matter is that the court usurped the province of the jury to find the facts. It was not up to the court to do Mr. Laws any favors, particularly where such a favor violated his right to a trial by jury. With respect to the second point, I'll be very brief. Our position is that the lower court here erred in failing to conduct any sort of inquiry after Mr. Laws informed the court that the jurors had observed him shackled in the back of a police car after the first day of trial. I think it's...
But counsel, did you object? Is that issue preserved?
Judge, I respectfully submit it is, perhaps not after Mr. Laws initially brought it up, in that he simply said he just wanted to preserve the fact that he was prejudiced by this encounter. But after the prosecutor disputed his factual recitation, Mr. Laws specifically noted that the two deputies who had escorted him to the police car were actually present in the courtroom. And he specifically said that both officers are here. They can attest to that, which I would respectfully submit put the court on notice that it should have inquired at least of the deputies, if not also of the jurors. And
so you're saying he impliedly asked for that inquiry to take place? Because he didn't, I'm not reading the record as saying that he made that specific request.
I'm not in a position to tell this court that he made an express request, Judge, but I think the fact that he said that the officers are right here, they can attest to that, I think is sufficient to put the court on notice that it ought to question at least the deputies with respect to what transpired. Lastly, I would note that the respondent's brief cites People v. Harper and its progeny for the proposition that the mere viewing by jurors of a defendant briefly in restraint does not require a new trial in and of itself. And we're not disputing that. The fact is, though, that People v. Buford holds that when a court is informed of circumstances where jurors may have been exposed to prejudicial information, the court is required to conduct an inquiry. And Harper and its progeny does not in any way limit that line of case law. And here we're not arguing that a mistrial was automatically required when Mr. Laws brought this information to the court. Instead, the court was required to conduct an inquiry, and it's that failure to conduct an inquiry which warrants a new trial here.
Does it make a difference that Mr. Laws was representing himself in this case and he didn't make that request specifically? And does he waive that kind of the ineffective assistance of counsel argument?
Judge, I'm not arguing ineffective assistance of counsel. I suppose if the court finds that he did not make a sufficient objection, then I'm stuck with the fact that this issue is not preserved. I would ask again, however, the court to consider Mr. Law's statement with respect to the officers being right there present in court who could attest to what he was alleging that put the court on sufficient notice to conduct a Buford inquiry.
Okay, you've got to be mindful of your time now. Do you want to hit the sufficiency argument?
Judge,
The weight of the evidence argument?
Judge, I'll rest on my brief for that argument unless the court has any questions.
Very good. Thank you, counsel.
Thank you.
Good morning, Your Honors. Michael Tantillo for the respondent. I will address point one first. Not to belabor the facts, but very quickly, the bank robbery occurs in the town of, or the village of Sodus, and fingerprints are attempted to be obtained. Many months later, a bank robbery occurs in another town, the town of Newark, and the defendant writes a letter to the prosecutor demanding that any fingerprints recovered from that bank robbery in Newark be compared to the prints that may have been recovered in the subject Sodus.
And in response to that, the district attorney's office does seek?
The district does what?
In response to that request, the district attorney's office does in fact attempt to get that information and do that analysis.
The DA's office does in fact do that. The prosecutor sent a letter to the police requesting that there be a comparison. And as she said in the court, I did this in court to appease the defendant. It came back negative. There was no match. Notwithstanding that, in his opening statement at pages 188 and 189, the defendant representing himself, excuse me, says, "I'm in jail for 8 months." And then they run the prints from another robbery against the prints in my case. They don't want you to hear that evidence. And of course, there's an immediate objection from the prosecutor because that's grossly misleading. And after some discussion, at which point the court is made aware of the fact that the request for the fingerprint comparison emanated from the defendant at that point says, "Okay, that's true. I have no problem telling the jury that." And when the jury is brought back in, he specifically says, "Those prints recovered from the Newark robbery, I'm the guy that asked the DA's office to run them and compare them." So it is our position that he has waived any subsequent complaint to the court, later reminding the jury, when the defendant again attempted to mislead the jury, of his original, whether you call it a concession, an admission, a stipulation, of his own personal statement that he was the one that requested that.
Mr. Tantillo, but Mr. Banaszak, obviously the way he addresses that is to say the court essentially directed the defendant to make that statement to the jury. But even so, there is no objection preserving any issue with that direction. So I'm not sure that helps either. And I don't know how we then get to a mode of proceedings error when there is no preservation of the connection between the two issues. At least that's how I see it.
Well, I think I agree with Your Honor that there is no preservation there, but I'm going to disagree with counsel when he says that the defendant was pressed to make this statement. There were about 4 pages of give and take, back and forth discussion, and it was the defendant on his own who says, "You know what, I can resolve this. I'll tell him that." And when he says that, everybody says, "Okay, fine, that's what we're looking for." Now, you have gotten into another matter that I wanted to address, Your Honor. The defense calls this, first of all, I submit it's no error at all, but the defense calls it a mode of proceedings error. But I've submitted a number of cases that indicate jury instructions do not constitute mode of proceedings errors, even if they're erroneous. There's only one exception. If a court erroneously instructs a jury and shifts the burden of proof on an element of the crime from the prosecution to the defense, that is a mode of proceedings error. That did not occur here. So harmless error analysis is appropriate. I don't submit for a moment that there was any error by the court, but even if you would like to call that erroneous, this court's subsequent reminding the jury of what the defendant stipulated to, it's harmless, first of all, because the defendant himself made those very statements to the jury, and secondly, because frankly, the evidence of his guilt was overwhelming in this case. Regarding the second point, the observation of the defendant and restraints, It's not at all clear that that even took place. The prosecutor said she was outside at the same time and there were no jurors there. But be that as it may, when the defendant brought that to the attention of the court, he did not ask for a voir dire of the jurors. He did not ask for an instruction. He did not move for a mistrial.
When he indicated to the court that those officers were present?
He did indicate
I
that.
mean, how's the court to interpret that? I mean, they're here, Judge, in other words, call them.
Well,
If you have any question about whether they saw it or not.
that's true. He did say that, but he didn't request any particular judicial intervention. And I would also point out here, Your Honor, you got to look at the big picture in this case. This defendant, from the very beginning, from the arraignment, was an extremely contumacious and abrasive and threatening person. And he had used up any credibility he had with the court long ago. But the point is, he made no request whatsoever for any relief of any sort. So he has not preserved this issue for appeal. Thank you.
Thank you. Case 603, People versus Rayang. Counsel, can you hear us?
I can hear you, Your Honor.
We can hear you. I apologize for the pronunciation of your client's name. Would you please help me with that?
I'm no authority on that, Your Honor. I think you did fine.
Okay, very good. Please proceed.
May it please the court, Lyle Hoydu for defendant Renning. In light of the amendment to the record, I would concede points 1 and 2 of my brief and focus on point 3. With regard to the weight of the evidence, and because I have lost my voice, I just want to highlight 1, that this is a highly circumstantial case. 2, it was dependent upon the testimony of a single key witness who was the injured victim. And 3, I would respectfully, excuse me, I would respectfully request that this court pay particular attention to the many facts and testimony that are highlighted in our brief that undermine and contradict that key witness's testimony. So unless the court has a specific question, I would rest on the arguments set forth in my brief.
Thank you, counsel. Mr. Hillary?
Good morning, Your Honors. I would just point out to the court that while Ms. Maldonado's testimony was, of course, highly important to the people's case, it was well supported by an abundance of circumstantial evidence. The court has the record. I could outline that for the court. If the court prefers I rest, I'll do that. If the court is sufficiently aware of those facts.
Well, the court's familiar with the record.
I'm sorry?
The court's familiar with the record.
Then I'll rest.
Very
Thank
good.
you.
Thank you, counsel. Case 604, People versus Simmons. Proceed, counsel.
Good morning, Your Honors. Jane Yoon for Jasmine Simmons. The court's misunderstanding. I would start by saying I'd like to focus the court today on point 3. I'm always happy to answer any questions the court has on any of my other points, however. But with respect to point 3, the court's misunderstanding of the DVSJA caused 2 significant problems here. Because first, a corroboration requirement as imposed by this court in this case is not a purely procedural requirement. It reflects also a substantive judgment on the survivor's testimony from the outset, which means that aside from the procedural requirement that the court thought was necessary to even get the DVSJA relief that Ms. Simmons sought, the court was really looking at her testimony from a biased point of view. And so we would ask that this court take that court's credibility determinations with a grain of salt and review all the facts that were presented at this hearing de novo, which this court can do, as was decided by the Court of Appeals recently. And the other problem too is this requirement of corroboration is totally against what the DVSJA stands for. Because the current understanding of DVSJA and Penal Law 6012 sort of incorporates this new understanding
So
about.
I'm sorry, I apologize. I'm gonna back you up just a little bit.
Sure.
Are you arguing that because the court misunderstood the cooperation requirement, that therefore the credibility determination of the witness before the court should be disregarded?
Yes, because once the court decided corroboration was required, the court made clear that unless there was corroboration, the court really wasn't going to believe anything that she said, which is sort of an older understanding of how DV works. It doesn't take into account the new understanding that we have of DV victims, that many times this stuff doesn't.
But as opposed to, can you point somewhere in the record where the court says that? In other words, or are you saying that because the court made the mistake, in your estimation, with respect to what was required in corroborating the evidence, that therefore he didn't spend enough time analyzing the credibility issue of the witness that was before him?
I would say the record does reflect that. Just in the court's decision, I would note too that the court's decision was pretty brief. The court at the outset says, I don't believe there's corroboration. There's no corroboration here. The court also imposed this sort of requirement that the facts establish self-defense, which is also contrary to what the DVSJA imposes.
But the court also made a finding with respect to the relationship here, and not the prior information that was brought before regarding other incidents.
Right.
Because I think the court credited that.
Yes, I agree.
Information. But with respect to the relationship between the victim and the defendant in that relationship, the court did not credit the credibility of the defendant and what the defendant provided.
That's correct. And the court pointed to the lack of the corroborating evidence, which is why I think in the circumstances in this case, it can't be separated. So Ms. Simmons was down a leg, but from the beginning of the hearing, because she wasn't set in a position where the court was hearing this information, with an open state of mind or with an open mind, because the court.
I understand your argument. Okay.
Okay.
Yeah,
Thank you.
interrupted you. You can go back to where you were.
And I would just say that if this court looks at the facts de novo, the court certainly can consider the lower court's credibility findings. We would just ask you to take it with a grain of salt because of these impositions that the court imposed on Ms. Simmons at the hearing. And, the standard it's been established that the standard at the hearing is preponderance of the proof. So I believe that the evidence did set forth each of the three prongs by preponderance of the proof.
Ms. Young?
Yes.
Taking a close look at the facts as best I can with the time allotted. Do I have it right and that your client knew the victim for, was it 2 weeks?
They met in late November, and this incident occurred in January, so a little over
maybe
month,
2 months. Maybe I've got that. Okay, so about 2 months, and sometimes she stayed with him, and sometimes she didn't.
I believe once they met, she was mostly staying with him. She did spend a few weeks, as the court knows, in a violation of probation, but that was basically, she had no other place to go. I mean, she was a drug addict who couldn't, maintain requirements to stay in regular housing, which is why when this offer came her way,
This is not like other cases where, at least that I know I've been on, I'm sure other members of the panel have been on, where it's a long-term abusive relationship. This is about a 2 month. That doesn't excuse abuse, obviously, but it's a shorter relationship. And on the night of the death, do I have it right that your client was in and out of that apartment in under 2 hours?
I think the timeline is a little bit unclear. I know that the people made some arguments and the defense made some arguments, and unfortunately, Ms. Simmons' memory from that night is quite fractured. So her testimony.
That's it benefited her. Is that a fair construction?
I don't think so. I think either way, her memory from that night. I mean, she has been very clear from the outset that she didn't really remember a lot of things until she became sober while she was in jail, and some of the memories were coming back to her. I believe she also testified both at trial and at the hearing, or maybe one and not the other, that she's not the greatest chronologist, so she wasn't watching the clock.
But in addition to 70 stab wounds inflicted on the victim with blood in a lot of different places, including, I think, on the door, if I recall correctly, she took the time to remove her belongings before she fled, correct?
I think they found some of her belongings still at the apartment, is my recollection. She testified she had 2 bags that she would keep her clothes in. She left with one, and one was still, I believe, in the apartment. I believe the police recovered that. So I wouldn't say it was all of her belongings. But with respect to the timeline, she has never said that I know exactly what time I came and went. And, you know, I think part of the problem is that she does have fractured memory. And I would point to Dr. Ceruli's testimony at the hearing saying that's not unusual for victims, survivors of domestic violence. And I would just go back to the combination of her testimony and Dr. Ceruli's testimony at the hearing established each of the 3 prongs. I know the court's familiar with the record. I would like to highlight some points, though, in terms of why I think the 3 prongs have been met, and if this court reviews it de novo would agree with me. Unless the court has any questions about why I think the lower court was wrong about corroboration.
Proceed.
Okay. We know that DV is not necessarily established by tangible evidence, and sometimes all we have is the report of the survivor herself. And again, I would point to the fact this was a short-term relationship, and you know, to the extent that we know that many survivors of domestic violence don't report incidents at the outset, that is also one way I think that this court can look at it. And there were problems. The last thing she probably wanted to do was call the police when this was a place for her to be off the streets in the cold Rochester months. And she even testified to that. She had been living on the streets prior to this offer from the 70-year-old man who was offering a 26-year-old drug addict who had no home. I think from the outset, there's an unequal relationship here. And so he knew she was coming back. And this wasn't out of the kindness of his heart. I know that the lower court seemed to think that the decedent was a nice guy and, offered up his home, but he was getting something in return. He was.
Well, let's just chat about that for a second, just so I understand, that I understand the record correct, right? The testimony, we have no testimony from him concerning that relationship, because he, of course, is deceased.
Sure.
So the testimony we have about the relationship and what he was getting out of the relationship comes solely from the defendant.
That's correct.
Okay. Proceed.
Okay. But this was on an unequal relationship. I mean, she also admitted that prior to moving in with him, she was surviving basically by prostituting herself so she could get her drugs. So it's.
At trial, the court heard the testimony from the daughter. Do I have that right?
That's correct.
And the testimony was favorable for the victim by the daughter.
Well, it was his daughter.
Understood. The court heard that.
That's correct. And I would, I would also, I know we don't like to do this. We don't like to subject witnesses to some, scrutiny because their parent has just died. So I understand that. But I'd say there was definitely liability problems with how well she knew her father. I mean, he lived around the corner. She testified that she went to go see him after she was concerned about a discussion they had on the 8th. She went to check on him on the 9th and I think again on the 10th. And then she doesn't do anything for a few weeks. And if she's that concerned about his ability to survive on his own without her help, that sort of strains credulity, especially because they have the same landlord and she said that she lived right around the corner. So I think to the extent that she painted him as this frail man who could barely get around by himself, I think that's, because I think that was part of the people's theory was that he wasn't in a position to be able to,
She got his groceries, took the doctor's appointments, paid his bills, and helped him bathe from time to time, correct?
She thought that's what she testified to. But between January 9th and February 5th, she doesn't make any attempts to try to find him. It's not until February 5th that she finally calls the landlord. And so if she's doing all those things for him, and she also testified that he was either talking to her daily or was with family daily and they always knew where he was. It's just strikes me as odd that between that time, she wasn't checking in on him if he normally checked in with her every day. So I think to the extent that they tried to paint him.
During this period of time, though, that the defendant had essentially moved in with him, though. Right?
During which period of time?
Well, I mean, the daughter was under the impression that her father was living with the defendant.
That's correct.
Right. And so when you said that the daughter wasn't checking up on him, like she had indicated she was, doing the things that Justice Curran had just outlined. When you say that it's hard to understand, if there's now somebody living with him, and presumably taking care of them and helping them with those things. Maybe she doesn't have the need to do it that often.
Well, I think based on her testimony, she had reason to believe that Ms. Simmons was not going to be residing there. So if, under those circumstances, it doesn't make sense that she wouldn't go check on her father, because in her mind, that relationship was going to be ending soon.
So the record reveals that she didn't think, she was not under the impression that the defendant was residing or spending time in that apartment.
I think beyond January 8th, I believe. So, and it's more just to say that, she tried to paint her father as a frail man, and that might be the man that she knew, that might be the man that she knew might not have drank a lot of alcohol in front of her. The man that she knew might not have been abusive in front of her. In fact, we know that abusers in the domestic violence context are quite manipulative, and they know what shows to put on in front of which people. And since she was not with him predominantly,
the defendant had a long-term relationship, was married and had a long-term marriage. Do I understand that correctly?
It's not clear. I think there might have been something in the PSI about that, but beyond that, it's not clear.
There's no history of domestic abuse in the prior relationship or in his past history at all, is it?
No, and it's not unusual. I think Dr. Cerulli testified to that. It's not unusual. And I think this court is familiar just in terms of real life anecdotes that we see every day. It's not unusual that abusers can hide in the public eye for a very long time, until something goes wrong. And something went wrong here. So I think that the preponderance of the evidence between Ms. Simmons' testimony and Dr. Cerulli's testimony is.
Well, the doctor's testimony is based on the records of the defendant's prior history.
That
in part.
Correct.
But also her indication to the doctor as to what the relationship with this victim consisted of.
That, in addition to Dr. Cerulli reviewed the police reports, she also reviewed the trial testimony, and she did say that
all of this is based upon what the victim said transpired between the two of them, what their relationship consisted.
Well, it's that in conjunction, you can't separate the two. So it's Ms. Simmons' testimony or Ms. Simmons' discussions with Dr. Cerulli. And Dr. Cerulli would even say they didn't really talk about the incident that much because Dr. Cerulli is more focused on the abuse that she was enduring and the connection between the abuse that she was enduring and the incident. But Dr. Cerulli was looking at police reports, the trial testimony. I think she said she tried to watch the police interview, but she had some audio problems, but she did review the materials from the trial. So it's not just Ms. Simmons' account. And I think Dr. Cerulli is also in the best position to determine whether or not she finds those accounts credible. And she did testify at the hearing that it wasn't an issue, that it was just Ms. Simmons' account of their relationship. It went along the line of instances of abuse that she had studied, and she'd been studying domestic violence and interpersonal relationships for 3 decades. So she's in the best position to know that. And I think it would also go against her credibility to agree to testify as an expert at a hearing like this if she felt that this was, there wasn't anything there. So I think the fact that her understanding of the relationship came from Ms. Simmons shouldn't be discounted, because Dr. Cerulli is looking at all this information, not just from Ms. Simmons telling her how this relationship existed, but because of all the other information there. And then I think Dr. Cerulli weaves in and ties in this past history of abuse, which I don't think anybody is disputing. I think everyone agrees that Ms. Simmons endured incredible abuse from a very young age. And, Dr. Cerulli's testimony was that this was ongoing. So even though the abusers from those relationships weren't in that room with her or that apartment with her for that short period of time, that past informed her ability to engage in healthy relationships. And she had none except for the one with her sister who had been murdered, which kind of sent her on the new trajectory of when she was back into substance abuse. I mean, she managed to make some headway on her own. She finished school, she was getting into college, and then the tragic death of her sister kind of sent her spiraling. It sent her mother spiraling, who ultimately succumbed to her addiction problems. Her stepfather then died, and then she was homeless. So she's homeless, she's a drug addict, she's on the street, she's 26 years old, and the 70-year-old man takes her in. I don't think there's any other way to really review that or take that information in to say that he wasn't getting something out of this. I mean, she was referred to him by his cousin, with whom she was getting drugs from. So I think that in and of itself creates the unequal relationship. I don't think you can ever say that this was ever an equal relationship from the start. And I think that ties into with the evidence regarding how the current abuse with the decedent and the past abuse that she had suffered just really affected Ms. Simmons' ability to make judgment calls. And so that, I think Dr. Cerulli explained that, saying that there was just really no way that she could separate her past from whatever she was engaging in that evening, in addition to which she was, she, by her own account, she had taken, she'd been drinking all night and taking drugs all day. So she was not in a, I understand that the jury found her guilty, but she was not in a state of mind to really maybe appreciate what's going on. So if someone's already had issues with judgment calls and, with all that, that influence happening, and then him coming after her, he had previously threatened her to kill her if he ever caught her sleeping with his cousin. And that night, when he demanded to smell her underwear, which also I don't think you can really say is part of a healthy relationship, but his jealousy drives him to, demand to smell her underwear whenever she's out without him, to come home after having been drinking and high. She's tired. She just wants to go to sleep. And this guy's grilling her. She's probably thinking, okay, you know what? It's not even worth denying it. Okay, I slept with G. And then he's really acting on what he had promised and threatened her in the past, that if he had ever caught her sleeping with G, he would kill her. So in that state of mind, with everything that's going on, we understand everything's happening in an instant. She reacted, and we have an unfortunate result here. But to the extent that she didn't have a healthy relationship with him because she couldn't have a healthy relationship because of the past, and I believe Dr. Cerulli was able to set that forth and did establish by a preponderance of the evidence that that second prong had been met. And then with respect to the third prong, which is
Counsel, you should be mindful of your time.
Thank you. I would just focus on the sentence that's unduly harsh, because without the DVSJ relief, she's only looking at a sentence with lifetime parole. I would point to Justice Singus's dissent in the Brenda W.W. case, where she talks about even putting someone on post-release supervision is a whole can of worms for someone who is a survivor of abuse, as Ms. Simmons was here. So yes, that would be a much more appropriate sentence for her, but even that, it will come with its own challenges. So it's not like a freebie. And so we would say that the current sentencing scheme, which only limits her to a lifetime supervision on parole, is unduly harsh.
Thank you. Counsel.
Thank you.
Good morning, Your Honors. Aaron Schwelly for the people. I will also just focus very briefly on the third point. At this hearing, defendant was obligated to prove by preponderance of the evidence two things, essentially. That she was subjected to physical, sexual, or psychological abuse by the decedent, and it was that abuse that caused her to kill this man. And on this record, I would submit that neither prong was proved.
Say that again. I'm sorry, counsel.
I would submit that neither of those
Neither
things
prong.
were,
Okay, very good.
were proven by a defendant at that hearing. And I would also submit that the court is entitled to make a credibility determination. And that's what the court did. And I think the credibility determination that was made is supported on this record. Unless the court has any questions, I would spin on that.
No questions, counsel. Thank you.
Thank you.
Case 606, People versus Jacobs. Counsel, proceed.
Morning, Stephanie Stair for Anthony Jacobs. Your Honors, I would like to skip straight to point 2 unless there are questions on point 1. The cases relied upon by the people on the issue of removal to family court factually are wildly different than what we have here. The YL and EBM cases deal with gang assault, where the issue is...
Ms. Stair, before you get into the meat of that,
Yep.
And I don't want you to lose your train of thought, but I'd like to take you to I think you have a contention that essentially says this issue is jurisdictional in nature, and that goes to your point 1, I realize.
Correct.
But isn't there a First Department case that says it's not jurisdictional, it's discretionary, that Clark case, I think?
So the Clark case is also procedurally and factually quite different from the facts that we have here. Procedurally, that was dealing with the extraordinary circumstances analysis. Our case was still at the 6-day review. So it is a different standard and procedurally in a different position. And again, factually, it was much different in that it was a gang assault where it was which defendant is causing which injury, not was a defendant causing the injury.
But the jurisdictional concept embedded in there is similar, right? Because your argument is it's jurisdictional because the court didn't have the power to act because it should have removed it to family court. I think
Correct.
that's the argument.
Correct.
And that would carry over to Clark as well, irrespective of the standard for extraordinary circumstances or causation. Am I right?
Yes.
So would it be fair to say on that issue, if we were to agree with you, we would have to disagree with the first department with respect to it being non-jurisdictional and discretionary only? Is that fair
Yes.
or no?
That's fair.
Okay.
That's fair.
Sticking with the concept that if we end up agreeing with the first department, should we go down that path? And it becomes, we determined that it's discretionary determination. I know this is not in the briefs, but one of the things that comes to mind is these types of statutory rights where the courts exercise discretion. Have you given any thought as to whether or not this is foreclosed by a plea?
I hadn't contemplated that.
It's fine.
Your
It
Honor.
would be, because it's not argued by the people, and I don't think it would be fair to you to bring it down that path. But in case it occurred to you,
Yeah.
I'd like to have that conversation, but we'll wait for a different case, I suppose.
I'm sure it'll come our way.
I don't know that for a fact. I'm not wishing it at anyone, but thank you for going down that path.
Yes, absolutely. So as I was saying, the gang assault cases, the YL and EBM cases are co-defendants both simultaneously causing injury to the victims. And the issue was who caused which injury and which injury rises to the level of significant physical injury. Here, it's completely different. And we're not asking for a bright line rule that accomplice liability is not enough. But it isn't sufficient on our facts. The co-defendant was the shooter, the only one in possession of a gun. Mr. Jacobs is actively running away from the car and importuning his co-defendant to also abandon this robbery scheme when the co-defendant kills the victim. The plain reading of the statute is that they have to have caused the significant physical injury. And going back to the legislative intent, obviously the overwhelming bulk of youth park cases were supposed to be removed to family court.
So Ms. Stare, me again. On this issue, as I read the motion papers below, defendant's counsel argued primarily, if not solely, that these charges under the murder statute, subdivision 1 and subdivision 3, were solely accomplice liability. Is it fair to say that is the key argument that the defendant raised below?
Yes.
Okay. And is it fair to say that the court rejected that argument?
Yes.
So the people in their brief and below argued that, wait a second, it's not accomplice liability only. The indictment for both subdivision 1 and subdivision 3 refers to alone or in concert. And that's accurate.
Mm-hmm.
All right. So if we determine that the defendant is simply wrong, that the indictment is not solely based on accomplice liability, we would affirm, correct?
I think it's a little more idiosyncratic than that. Because we're not asking for that bright line rule, right? I'm saying on our facts alone, because these determinations are supposed to be so fact specific, right? And causation can be fact specific even when you're not talking about a youth park case.
But that's why I kind of set it up that way on purpose. And I'm not trying to trick you. I'm laying it out.
Yeah.
So I thought the argument was solely, hey, this is solely accomplice liability, and the court disagreed with that. Now you take it down the facts and circumstances path, and I'm prepared to do that as well. So subdivision 3 is the felony murder statute.
Right.
So with respect to causation, the issue is not what your client's conduct, whether or not it caused the murder in the general sense. It's whether the felony that he committed allegedly caused the murder. Do you agree? Under subdivision 3, not 1.
Well, I would argue he didn't commit a felony.
I'm sorry?
I would argue he didn't commit a felony. It was an attempted.
He pled to it.
He pled to an attempted, yeah.
Well, that's what he was charged with, attempted
Correct.
robbery.
Correct.
So if during the course of the attempted robbery, that attempted robbery caused the death, we would then look at the CJI's definition of causation in a homicide, which I think generally speaking has two elements: link in the chain, you've seen these before.
Yep.
And foreseeability.
Right.
So wouldn't we have to interpret the word cause in these particular circumstances, to use your focus on the facts, to look at the felony murder and whether or not that felony was a link in the chain and was foreseeable? One could argue, right, under that standard, that in fact, attempting the robbery, holding the door open, blocking the vehicle was a link in the chain that was foreseeable.
One could argue that, yes.
Now, I've just asked a bunch of questions. This is
Yep.
what's on my mind. Do you have
Yep.
any other response to it? I don't want to cut you off.
Well, you know, the cases that were cited by, I believe, trial counsel and me in my brief sort of contemplate that, right? There's the case, People versus KF, where the co-defendant set up the drug deal, which put into motion a drug deal gone wrong, which ends up with someone being murdered, right? Very similar here in that they started as the attempted robbery, something goes wrong, someone ends up dying. In that case, People versus KF, and again, it's not mandatory authority. However, the court found that the prosecution didn't show foreseeability, like you were saying, Your Honor, that the defendant knew or should have known his co-defendant was armed and had the intent to use it to cause significant physical injury. So there's the setup, it goes wrong, there's a death, but they found that he wasn't the cause of the significant physical injury. Here, Anthony's in the same position, right? They have the attempted robbery that they are both.
Can I slow you down, KF?
Yes.
Looking at that case, it's clear that the court described the people's position as being based solely on accomplice liability. So it didn't involve our fact pattern that we have here vis-a-vis subdivision 3 with felony murder. I mean, I did my best. By the way, the briefs were great. This is why it attracted my interest. So, but I think a lot of these cases, they make a point in the court's decision as saying it's solely accomplice liability, which probably would prompt the defense counsel to argue that primarily.
Right.
So when you go down KF or any of these other cases, I think I'm going to need to know, do they base solely on accomplice liability? I think by and large they are.
I would be happy to do a post-argument submission and look into that more.
I wouldn't want to inflict that on my family or fellow panel members, but I'd be curious as to your position on that.
Okay,
And
absolutely.
stay with the people. I
Absolutely.
think it's generally covered by the briefs. I'm not saying you have to do it. And you can tell that, we've all dug in.
Yep.
So.
I'll go back and double check and I'll submit something if I.
Request permission, so that.
Thank you.
Thank you.
I think we're good on point 2 unless there are any other questions. Okay.
I do have a question. Assuming that it was nothing that the case should not have been transferred to family court, you still, and because the people objected, and assuming they filed the objection within the 30 days, you still would go to special circumstances, don't you?
Yes.
And that is the issue of whether or not that burden has been met, correct?
So the extraordinary circumstances analysis, yes, would be the next step.
Okay.
And I do concede that the people would be entitled to that if it were remitted at that point.
And I don't know if you came across in your research, but there's a relatively new, probably by Justice Chambers out of the Second Department, an opinion on that subject.
Yes. Okay, so on point 3, we are challenging the denial of youthful offender. To quote trial counsel, if not Anthony, then who? I'm not going to belabor the standard to make Anthony an eligible youth. I think there was sufficient mitigation to show that he would be an eligible youth. The PSI in this case, it's rare to see a PSI as positive as this. Your honors all see as many PSIs, if not more than I have. Even the assistant district attorney said it was the best PSI he'd ever seen in 21 years. It described Anthony as cooperative, pleasant, and providing thoughtful statements with genuine affect, ownership of his involvement, introspection and reflection upon his behavior. listed 10 areas of strength, only 4 areas of problem areas, 3 of the 4 only being listed as possible. The defense counsel noted at sentencing that both Anthony and the probation officer cried through the entire interview in the office. Most importantly are the letters of support. I'm not going to go through all of them. I know the court has reviewed them, but I do want to highlight the one from Carrie Pardue. She is a 30-year veteran of the Monroe County Children's Detention Center, and she said that she had never worked with a young man with the characteristics and maturity level of Anthony. She described how he helped develop programs at the detention center, both for staff and for the other incarcerated youth. He refurbished and cared for the vegetable garden. He got his high school diploma. And she said she had never worked with such an intelligent and caring young man with unlimited potential. And she asked the court to consider a sentence that would return him to society sooner as opposed to later. We don't see this, right? We don't see facts like this. We don't see someone who has rehabilitated himself so quickly and so wholly after the worst mistake of his life, right? So we are asking that the court find him an eligible youth and vacate the conviction and resentence him to no greater than 1 1/3 to 4. In the alternative, we are arguing that the sentence that he received of 15 years is harsh and severe. This court very recently in Hannah T. quoted that the court has the inherent power to correct a sentence that is unjust in its relation to the crime. And we are not discounting the crime here. Obviously, a man lost his life, and that is horrific. But his lack of involvement in the violent act was no less than Hannah's involvement in that case. And all of the factors and things that I covered under point 3, I think go to the harsh and severe under point 4. Anthony's minimum under the statute is 3.5 with 5 years of post-release supervision. And we would ask that the court consider resentencing him to 3.5.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Ryan Ash for the people. Shall we address your questions about what is really going to the heart of the jurisdictional issue, Your Honor, with whether or not a court's exercise of authority that is given to it on a statutory basis is a jurisdictional issue merely because it determines which court subsequently will have jurisdiction over it. And of course, the people would submit that it's not a jurisdictional issue because the court was granted the authority to make that decision. And the question about what the cause element and whether or not we're looking at the indictment and those materials or the specific facts and circumstances, I think I was kind of on in that direction a little bit in my brief, but I think you have delved down into it quite a bit more than I was prepared to catch on my own at that time. But I think I did touch on it a little bit when I think I mentioned in my brief that the indictment did specify that he was acting alone or in concert.
I italicized it, which among other things caught my attention.
You know, and I think rereading my brief, I didn't write emphasis added. I think it was my emphasis. But at the time that the court's making this decision, all it has in front of it is the indictment and the allegations in the bill of particulars, which I believe was filed at that time, and the moving papers. This isn't a situation where the court is making this determination after there's been a trial, or in this case, a guilty plea where there's been a colloquy on the record about what actually happened. The court is, making this determination at the outset before the facts have been found.
And he didn't plead guilty, I haven't figured out whether or not we can even look at that, but putting that aside, he didn't plead guilty to attempted robbery as an accomplice because there's no 2020 citation or 20, section 20, accessorial liability section. That's not referenced in the conviction certificate as I see it. So it's
right. And I don't know how much that actually would impact this because of that chain of events. I think the determination is before that anyways, but I think I think, right, and that's kind of getting into the, before we get into the whole, what does the raise the age statute mean by when it says causation?
He may have only committed, if at all, subdivision 1, intentional murder in concert, but it's completely conceivable that he acted alone with vis-a-vis attempted robbery.
Right. And I think his actions would satisfy that subsection regardless of whether or not there was somebody there, and whether or not a death ended up resulting from it. His actions constituted, at least as pled, a sole actor theory of attempted robbery. Moving on to points 3 and 4, which I agree with counsel are kind of similar. The court didn't abuse its discretion in denying to adjudicate defendant as a YO. And yeah, once again, for the same reasons, his sentence is not harsh and excessive. And to the extent that it's relevant here, which the people would argue that People v. Hannity is not necessarily relevant here because the majority in that case effectively said this is an exception to the rule, not the rule itself. The people would maintain that, respectfully, People v. Hannity was incorrectly decided for the reasons stated in the dissent. But when we do dig into why that case came out the way it did, it's important to note that it was essentially the PSI in that case was the exact opposite of what we have here. What we have here is someone who was mentally capable of rationalizing what to do in each circumstance and what right and wrong meant. And the fact that the supporting letters were emphasized by everybody, including the ADA at sentencing, I just view that factually different from the rationale that supported the decision in Hannity, because here, his previous good character before committing the crime doesn't trigger the same sort of fundamental fairness concerns that were present in People v. Hannity. And I think that in order to trigger this court's inherent power to review something that maybe the defendant made a different decision about whether or not to foreclose it, review of that issue, I think that that should be reserved for the very, very extraordinary case where the system itself has kind of failed to account for the protections to be afforded those people. And the defendant here, while it's commendable, and I agree that the PSI and the letters of support stuck with me as well. I remember them from originally reading them, several months ago. It's commendable that he has turned his life around essentially as much as he can while he's serving the sentence. But at the same time, it is factually distinct, but also I think legally and intellectually distinct to say why this court did what it did in People v. Hannity and why I don't think it tracks that it should do the same here, because the cases, I think the rationale is just completely different. So if the court doesn't have any questions, I would rest on my brief.
Thank you, Cal.
Thank you.
Case 608 in the matter of Dariel P.E.
Your Honor?
Yes, counsel. Hold on. I think we're waiting. Are we waiting for Counsel Pierce? No, Pierce is here. Counsel Marin. There we go. Very good. Can counsel all hear us?
I can hear you, but I only see 3 of the 5 judges.
You only see, I'm sorry, what?
I only see Justice Curran, yourself, and Justice Smith. I don't know where
Okay.
the other ones went.
Well, maybe as we speak, maybe our pictures will show up. Okay, but can you hear us?
Yes, but I can hear you. Can you hear me?
Yes, we can. Counsel Pierce?
Yes.
I can hear you, Your Honor. Can you hear me?
And we can hear you also, and Counsel Marin.
Your Honors.
Very good. Thank you. Please proceed.
Okay, thank you, Your Honor. I am representing Denisha EC in this matter, where the department alleged the allegation that her rights should be terminated over all 6 children. on two theories, abandonment and permanent neglect. Now, we admit that the standard for abandonment is very high and that, I'm sorry, the burden of overcoming the presumption of abandonment is high. We believe she did meet that because she didn't really abandon any of the children or fail to communicate with the department for the 6 month period that the law requires, because as Ms. Lee did admit that she had at least 50 contacts with her. She did
We
visit
don't
with the
know, we
children.
don't know when those 50 contacts were. We don't
But
know if
they-
this happened starting in February 2022 or not.
Right, but the thing, but Your Honor, but they did have those contacts. I mean, but the very fact that she remained in contact with them is indicative is that she there was no intent to abandon the children. And she also visited with the children. And I also would respectfully point out that while she never may have presented specific documentation about her pregnancies, her difficult pregnancies, is that that the department was aware of the pregnancies, and therefore that I don't think that that her failure to appear for some of the visits because of the difficult pregnancy should be held against her.
Counsel, let me just see if I understand your argument. We're looking at a abandonment period for purposes of this determination from February 2022 to August 2022. Is that right?
That would be correct.
All right. And so the number of contacts that you just referenced, I think in answer to Justice Smith's question, you indicated that we don't need to know when those contacts happened because they indicate a desire to have contact and not abandon the children. Is that right?
I would correct that, but my notes do indicate that it says, well, for much of 2022, after the children had been remanded, she did visit with them. So I mean, I would say that even after the February 22, that she did maintain at least some contact. Now, I agree that we may not know the exact dates of the 50 contacts that she had with Ms. Lee, but I think that would evoke an intent not to abandon the children.
But so just so I'm clear, you're not arguing that if there's 47 contacts that predate the 6 month period, that all of those should be considered for purposes of actually having happened within those 6 months. Because that's what we're focused on. We're focused on the 6 month period of time here and what were the contacts then in order to determine whether there was an abandonment during that period, right?
Well, right. I mean, I think you do have to look at the 6 month period, but I do think at least some of those 50 contacts did take place during that 6 month period. I don't think she just disappeared entirely. I mean, she did have the pregnancy. The department was aware of the pregnancy, so I think that.
So of those 50, some are delineated to have fallen within that 6 month period, and we can find those where in your brief for reference.
Probably in a record, because I mean the exhibits are very extensive. So I mean I believe that they did present all the timesheets going back because this is actually a very lengthy case that goes back a number of years. So I think you would be able to find that in the exhibits themselves, as well as not so much in the testimony, but in the.
So your suggestion is just comb through the record and we'll find when those 50 occurred and figure out whether they fell within the 6 month period.
That would be correct.
Yeah, thank you.
The point two would be the permanent neglect branch. Unless there were no further questions concerning abandonment, I will move on to the permanent neglect. She did not complete some of the programs, and that's true. But my client does have very extensive mental health counseling, and a lot of the programs that they were referring to her don't really lend themselves to get it done in 6 months, get it done in 1 year. I mean, a lot of her personal issues do lend themselves. I wrote in my brief, some require lifetime counseling. I mean, there's some problems that you can get resolved in 6 months, and there's some problems that go on and on and on. I mean, that's just the reality of psychology, unfortunately. So I don't think that her failure to necessarily complete mental health program should be held against her, because I think that should be viewed as a continuing problem for her.
But it's I'm looking at the mental health counseling issue, and it appears to me, and tell me if I've got this wrong, that a review of the record indicates that it's not that she didn't complete these necessarily, because we get those cases where people attend but they don't complete. In other words, they're there, they're participating, but they don't complete the program. But in this case, it appears that she failed to attend the counseling sessions. Is that right, or do I have that wrong?
I think that partly you do have that right. I mean, she failed to attend some of I mean, the record is clear on that one, that she did fail to attend at least some of them. But again, she did attend others, and I think that that should not be held against her, because when you look at her whole life, Your Honor, you're seeing somebody, she had experience with the children, the mental health issues, domestic violence. I mean, the department never presented any evidence of actual domestic violence, but she did complete the domestic violence class with Hispanics United, who did also provided her with a house, or not a house, but really shelter, for a while. That was Hispanics United Rapid Rehousing Program. So I think that she dropping the hammer, or dropping the axe, and terminating the rights over the 6 children may have been harsh under these factual circumstances, because the record is what it is. I'm not going to say she completed everything and she can get the children back right now, but the record does show that she did make an attempt to implement at least part of the program. And I think at the time she was also working at Texas de Brazil. I don't know if she still has that job, but our argument, therefore, Your Honor, would be that the rights should be restored, and you could send it back to family court for further proceedings to see what programs would be appropriate for her.
Mr. Greenberg, thank you. We'll take a look at that.
Oh, you're welcome, Your Honor. Any other questions?
No questions, counsel.
Okay, great.
Counsel, proceed. Counsel Pierce.
Thank you. May it please the court, Michaela Pierce for the petitioner respondent, Erie County Department of Social Services. I will start on the abandonment issue. Respondent appellant evinced an intent to forego her parental rights by her failure to visit with the children. On August 29th of 2022, the department filed the abandonment TPR petitions for all 6 of the children. 3 of those children she did not visit at all between February 2022 and September of 2022. The other 3 children she only visited in the relevant time period once in April and once in June. Matter of Armani W. states that visiting children only twice within the 6-month period constitutes sporadic and unsubstantial contacts, which is not enough to overcome the finding of abandonment. Moving on to the permanent neglect issue. At a minimum, parents must take steps to correct the conditions that led to the removal of the children from their home, per matter of Jeanette G. While she did complete a parenting course, there were ongoing concerns of her parenting during the relevant time periods at her supervised visits. While she did complete 2 mental health evaluations, she did not comply with the recommended treatment, and she was unsuccessfully discharged from those agencies.
She has not had a realistic plan for housing, stable housing either. Is that correct?
Yes. She did briefly secure housing, but then she lost it in December of 2021 and never provided any proof of finding housing after that. She did complete a DV course, domestic violence course, but she continued to be in domestic violence situations after such, and she even admitted to a domestic violence situation in which she was arrested within her best self evaluation. Additionally, regarding the permanent neglect timeframe, she only attended 60 of 169 offered visits, despite getting a transportation stipend. It's also clear that the department provided diligent efforts and that she was able to link with all of these services. She was provided a stipend, and they attempted to try to assist her with all of the things that she was struggling with. There was clear and convincing evidence to support both the findings that she permanently neglected the children and that she abandoned the children. And therefore, this court should dismiss the appeal and uphold the findings of abandonment, the findings of permanent neglect, and the finding that the subsequent termination of the respondent appellant's parental rights was in the best interests of those children. Unless there are any questions, I would rest on my brief.
No questions, counsel. Counsel, may I make a suggestion, though? We were able to hear your argument, but it was a bit of a strain. I'll speak only for myself. It was a bit of a strain to hear you through the microphone that you're using, and for purposes of future arguments, you might want to think about upgrading that equipment. Thank you, counsel. Counsel Marin?
Good morning, Your Honors. May it please the court. I am Natalie Marin on behalf of the children. I respectfully submit, Your Honors, that the family court's findings of abandonment and permanent neglect should be upheld. I do want to highlight from point one, as was highlighted by counsel, the respondent visited 3 of the children 2 times during the relevant time period and did not visit the other children at all during the relevant time period. I would further highlight that, as in Jasmine J, in that case, the respondent did have contact with the petitioner. It was at court. And in that case, that was not a substantial contact to defeat the finding of abandonment. And as was stated in our Marnie W and Kaylee Z, the sporadic and insubstantial contacts in those cases, which were minimal contacts, did not defeat the finding of abandonment. As to point 2, I would rest on my papers, Your Honors, and I would be open to any questions and any updates that the court may want about the children at this time.
No questions, counsel? Thank you.
Your Honors.
Submitted. Yeah. Just. This case 621 in the matter of Cason C. Counsel, please proceed.
Good morning, Your Honors. Great to be here. Winston Brownlow for the appellant father. Your Honors, there is no dispute in the briefs that the New York courts, like the courts of every state, lack subject matter jurisdiction to entertain petitions and proceedings which collaterally attack the final and binding judgments entered by courts in other states. This rule was established definitively by the U.S. Supreme Court in Johnson against Muehlberger back in 1951, and it stems from the full faith and credit clause of the Constitution, of the federal Constitution. Johnson was even a case that actually reversed the New York Court of Appeals in going the other way and permitting a collateral attack. This rule is a matter of subject matter jurisdiction. It can't be waived. Preservation is not required. It can be raised at any time. The First Department in Levesque very explicitly said this is a lack of the jurisdiction of the subject matter, and the Court of Appeals summarily affirmed that opinion. It's also undisputed, Your Honors, that neither exception to the collateral attack rule applies here, meaning Texas does not permit its own judgments to be collaterally attacked. And there's no question that both parties appeared, everyone appeared in the Texas court, and that the Texas court had jurisdiction of the underlying proceeding. So this court is left only with the definitional exercise that, is this a collateral attack? Is the New York proceeding a collateral attack? I submit that it unquestionably is. When you look at the very definition that my adversary submits as the definition of a collateral attack, it's from a trial court case in 1941. I've submitted a little bit more modern versions of that standard, but it tracks, it's entirely consistent. And the 1940s case says specifically that a proceeding is a collateral attack if it is instituted in an attempt to avoid, defeat, or evade or deny force and effect to the existing judgment. Your Honors, an adoption proceeding by statute, if successful under DRL 117 sub 1, results in the permanent and complete termination and elimination of all parental rights by the biological parent. Contrast that to the rights granted by the Texas judgment. The Texas judgment makes the father, gives him joint custody. It gives him extensive visitation and phone call, and makes extensive provisions about holidays, gives him all sorts of rights. If you grant the adoption petition in New York, you are necessarily evading, defeating, and denying force and effect to the Texas judgment. My adversary admits as much. He says in his brief that the New York adoption proceeding, if successful, will make, quote, a dead letter of the rights conferred to the father in Texas. That is a quintessential collateral attack. It is unconstitutional. It deprives the New York courts of subject matter jurisdiction. And the only thing for this court to do, Your Honors, I respectfully submit, is to reverse the judgments appealed from dismiss the proceeding, and send this matter back to Texas. It is simply not the case that this outcome would, prevent these children from ever being adopted or any of the parade of horribles that were articulated in the opposing brief. This simply requires, consistent with any other proceeding, as this court previously held in Crane back in the 70s, that they have to go to Texas and they have to remove the rights that were granted to him by the divorce judgment, and then he can be adopted. Then you can proceed with the adoption. There's one additional step, and that's simply a fact of consequence of the marriage. If there are no, I would add, perhaps as an update, and this isn't in the record, but I'm informed subsequent to the filing here that the children have moved back to Texas, that everyone is back in Texas now, and that there has been a proceeding of some kind. I don't know their procedure. There's been a proceeding of some kind that has been instituted in Texas with respect to these children. Whether it's an adoption proceeding or custody, I'm not sure. But these children are now physically in Texas. They are in front of the Texas court. This case has no connection to New York apart from the random fortuity of the petitioner's military placement at Courtroom. And I would ask your honors to simply vacate. Yes.
I need just to clean up what I think is a minor procedural issue, just so I have it. You make the point in your brief about 5520C.
Yes.
This order, that order.
Yes.
Just so you know, the way I read it
Yes.
is that 5520C has no application here for a variety of reasons. First and foremost, that those later orders that you have put in the record from which there's been no appeal taken, I view those as further intermediate orders. I view those as nothing more than what we already have on the record from which there's an appeal.
That's fair.
I don't think that they're a final judgment that we have to even look at 5520C.
That's fair.
Even though you make that point, is it fair to say that it's okay if we back away from that point?
That's fair. That's fair, Your Honor. I would note that my adversary conceded that 5520C does apply and that you would deem the appeals taken from the subsequent order.
That doesn't control us, but we don't even
100%.
We don't even need to
Yes.
get there because those later orders
Yes.
are really just orders that reflect what was already on the record. They're not final judgment.
Yeah, they're just standard. You would just say they're just standard. The family court practice of just constantly issuing new confirmatory papers.
Because the court said, give me an order.
Right.
And we get to it.
Sure.
So they're not final judgments. We don't have to worry about even whether or not we apply 5520.
Judge,
is that fair?
To be very honest, I included that point in a belt and suspenders approach, just to make sure that, in case there was any dispute, because there are these subsequent orders which predate, I don't want anyone to come and say, oh, a matter of AHO, now that, the original one has to be dismissed.
So you're not even waiting for us to address that in our memorandum, are you?
Your Honor, I would never, I would never surmise to advise the court on what to put in its memorandums.
Fair enough.
Never.
Thank you, counsel.
Thank you, Your Honor. Unless there are any other questions on this subject. Thank you, Your Honor.
Good morning, Michael Steinberg. In fact, there is an adoption proceeding I have found out going on in Texas. And I have been trying for quite some time with a client that I have trouble getting in touch with to get them to do something about the New York proceeding. I had written to Mr. Brownlow in May suggesting that we do a stipulation that would withdraw the New York proceeding and basically have this appeal dismissed as academic, because I think it is academic. I just can't get anybody to say what I would need them to say in order to have the court know for surety that it is academic. And I understand why Mr. Brownlow would not agree to withdraw his appeal without something that definitively says there's nothing left in New York. Nobody has moved in New York to dismiss the New York adoption proceeding for failure to prosecute. And my clients seem to think that it's worth having this stub of a proceeding in their back pocket. I'm at a loss to know what to do, but I thought the court ought to know what's going on. I'm at a bit of a loss to respond to Mr. Brownlow because there's so much here that makes no sense at all. This is not a collateral attack. The Texas court did not determine that Mr. Colwell has certain rights as a parent. Those parental rights came about because he was the father of these children. And under the logic of this collateral attack argument,
it would seem that anybody who in a divorce has gotten custody or visitation rights would be forever immunized against any proceeding that says, on the basis of conduct after the divorce, that person has shown an intent to forfeit her or his parental rights. There is no determination that Mr. Caldwell is entitled to parental rights within that divorce decree. It's presupposed. It was never attacked. It was never at issue. There is no order in Texas determining parental rights. And even if there had been, the fact that later on he may have abandoned his children is not a collateral attack on the judgment as it stood when it was issued. There would be no end of mischief if Mr. Brownlow's theory is adopted. There would be no way for children to be protected if a divorced parent abuses them, for that matter, or neglects them. The DSS would probably move to terminate parental rights. And under Mr. Brownlow's theory, they couldn't do that because apparently there's a foreign state judgment that says that the parent has these rights, and that would have to be attacked in the foreign state before the children could be protected here. I don't see any reason for that to happen. I don't see any case in which, under these circumstances, the collateral attack rule has been applied. This is a very straightforward case of somebody who had parental rights and then let them go to hell. That's something the court found as a matter of credibility. That's something that's defined by the domestic relations law. When the appellate division, when the legislature said a parent evinces an intent to forego parental rights by failing to contact a child for 6 months, although that parent had the ability to do so, that defines an evidentiary standard. That's what evinced means. It means this conduct shows that intent. There is no additional intent requirement that must be established. And in fact, one of the cases that Mr. Brownlow cited, Madeline S., says, of course, abandonment is established if the natural parent made no attempt to have a relationship with the child and the natural parent's contact with the child was never thwarted. I think that in itself puts paid to the idea that even though the court may find that the parent didn't try to contact the child for 6 months, it has to conduct a second inquiry into the private operations of the parent's mind to say, well, maybe they really wanted to be in touch with the child, so they weren't intending to abandon the child by abandoning the child. This is actually a very straightforward case. We may disagree, certainly Mr. Brownlow and I disagree on the factual findings made by the trial court, but the trial court made factual findings from his review of the testimony before him, from a review of the credibility of the parties. He said Mr. Caldwell has said that he was prevented from contacting the child, but there is no evidence that this was the case. If that isn't a credibility determination to which this court should defer, I don't know what is. But over and above that, I'm not sure that this case actually gets anywhere because I can't see that any New York court would exercise jurisdiction over an adoption that's taking place among people who are not in New York State and are not coming back to New York State. But that's not something that I can deal with. And that's not something that can be done in the context of this appeal. And Mr. Brownlow makes the not insane suggestion that, maybe we should just throw the whole thing out, but we can't. This court has a specific order in front of it, which is simply one that dispenses with Mr. Caldwell's consent to the adoption. And I'm afraid that's all we can do, all we can work with.
Thank you, counsel.
Thank you.
Case 623 MTG LQ Investors LP versus Severi.
Good morning, Your Honors.
Counsel, my understanding is the appellant has submitted.
Yes, Your Honor. So basically, I'm here to see if the court had any questions. I would just say that even since both parties submitted their briefs on this appeal, there have been further cases discussing the retroactivity of the application of the FAFA legislation. One such case directly on point with regard to CPLR 205-A is Deutsche Bank versus Vista Holda, 239 AD 3rd, 830. And that's a Second Department case, which directly addressed the case, the issue of the savings provision and that provision not being available in cases where there was negligence on the part of the lender and the prosecution of the action. Now, this action was actually previously before the court. Judge Curran sat on the panel in that case. And at that time, the court held that the lender did indeed get the benefit of the savings provision. However, a month after that decision came out, FAFA was made into law with the signature of Governor Hochul. And part of the FAFA legislation included a clarification of what negligence precluded a party from getting the benefit of the 6-month extension. And that includes 3404, the basis upon which the prior action in this case was dismissed. So I think that it's clear with the due process considerations and the clarification by the legislation to change and clarify those provisions of the law that are precluded from the benefits of the savings provision include 3404, which was the basis in the previous summary judgment motion in this case, in which the complaint was reinstated. I believe that the new legislation supersedes the prior decision in this case, and that the court below properly dismissed the case as against the lender.
Thank you, counsel.
Any further questions?
No questions.
Thank you very much.
Case 625 JSC Management Group LLC versus West General Contractors LLC.
Morning, Your Honors. May it please the court. My name is Robert Marks, and I'm an attorney with Woods Ovia Gilman on behalf of Plaintiff Appellant JSC Management Group. As this court is no doubt aware, our appeal is unopposed. I am certainly prepared to argue today and answer any questions that you may have, or if the court would prefer, I can rest on our unopposed submission. Does the court have a preference in that?
It's completely your call.
Thank you, Judge. I'll briefly summarize some of the points, but feel free to stop me at any point. Regarding defendant respondents' 5th and 6th counterclaims, which is point 1, we ask this court to reverse the lower court and dismiss both claims under the doctrine of collateral estoppel. Both of those claims represent negligent misrepresentation and fraudulent inducement, which was decided by the lower court in the third-party claim, dismissed in August of 2022. That third-party claim was brought by West against JSC's corporate representatives. It is the same foundation on the case, the issues in front of this court. Go ahead, Judge.
I hate to do this to you, but can I redirect you for a moment?
Please.
And could you go to the 10th counterclaim?
Yes.
For implied indemnity, please.
Absolutely, Judge. So for that point, which is implied indemnity, as you indicated, we believe the burden was first improperly shifted upon West, improperly shifted upon JSC. The court found that JSC did not set forth sufficient proof that West owed it a duty. We believe that it was West that needed to determine and to demonstrate that what JSC owed it any indemnification duty. In order to be entitled to indemnification, West has to demonstrate that it delegated to JSC exclusive responsibility for the duties giving rise to the loss. Not only did it not demonstrate that duty, the lower court specifically found in its factual findings that the 2021 agreement between the parties shifted the responsibility for all things associated with the work, including payment, to West. So JSC was the one who delegated the duty to West, not the opposite. So I don't believe there's any facts whatsoever to support the idea of an indemnification obligation. We pointed this court to the trustees of Columbia University versus Mitchell Giorgorla Associates in our brief, and I think that's instructive from the standpoint of there's an agreement between the parties, and either West demonstrates that JSC breached the agreement, or JSC demonstrates that West breached the agreement. But in no situation would there be some sort of indemnification obligation on JSC to pay West for some unidentified third-party loss. So I'm not sure, frankly, where the court went with that. Turning back ever so briefly to the first point, Judge, I'll just point to the language of the 2022 decision from Justice Sotorisi. That decision specifically found that the allegation of fraud and the negligent misrepresentation and fraudulent inducement relate directly to the contract sued upon West in its counterclaims, and that those fraud claims are duplicative of the breach of contract claim. So I think by the lower court incorrectly determining that they could be pled in the alternative, ignored that express decision that was already found. And West obviously had every opportunity, in fact, did litigate and have every incentive to keep that claim alive. So we are allowed to use collateral estoppel to prevent that claim. Does the court have any other questions?
No other questions, Counselor.
Thank you, Judge.
Thank you. Case 627 Richardson versus Tops Market LLC. Counsel, I believe appellant has submitted.
Yes, good morning, Your Honors. Yes, we recognize that appellants have submitted, and unless the court has any specific questions, we would also rest on our brief.
Very good. Thank you, Counsel.
Thank you.
Case 628 in the matter of Alice R. Lang, deceased. Proceed, Counsel.
Good morning, Your Honors. Katie McGraw, Bonshanick and King on behalf of Appellant Gregory Lang. This case is nearly identical to a case that was decided just in June of this year by this court. Justices Smith and Hanna were on that panel. That's the matter of Sawkins case. It's the precise issue before the court, which is whether a child of a principal has standing under the general obligations law to compel the attorney in fact to account for transactions taken on behalf of the agent, on behalf of the principal, sorry. The arguments in that case were a little bit different. The question that comes from the Niagara County surrogate in this case is whether the standing of a child under general obligations law 5-1510 is stripped or somehow revoked upon the principal's death. There's nothing in the statute that suggests that. In fact, there are other provisions of the statute that certainly carry over after a principal's death, and numerous cases cited both in our briefs and as recently as the matter of Sawkins case stand for the principal, or rather they support that standing is not somehow revoked or undercut by the death of a principal. I will rest of my papers for the remaining arguments, although I'm happy to answer any questions.
Here, Counsel, just a quick question. His petition, has there been an application to amend the petition to add a claim against respondent in her position as trustee of the trust that the court had granted the right to file that amended?
So there's a proposed amended petition in the record. There's what had happened was the cross move for to amend the petition. That portion was granted on the original order of the surrogates court. We later moved to re-argue on this issue of standing under the general obligations law. So that petition, that amended petition rather, with those claims has not been filed pending, this appeal, because I think primarily our application is under the general obligations law, and that issue remains outstanding until this appeal is decided.
I just need to know the status of it.
Okay, yes, and not filed yet.
All right, thank you, counsel.
Are there any other?
Questions? Thank you.
Thank you.
Good morning, Your Honors. Rob Gerbach on behalf of the respondent, Marcia Dixon. And I'd like to start by addressing the necessity and the importance of the appointment of a personal representative to represent the estate. This petition was brought against a deceased person, and there's no estate to represent that deceased person. And that becomes problematic. I mean, first of all, it's necessary. If I'm going to sue somebody representing a plaintiff and my plaintiff is deceased, I have to get an estate in place to do that. If I'm suing a deceased defendant, I have to get an estate in place in order to do that. In this case, we're doing an end run around the estate situation in that we're taking the general obligations law, which has now been expanded to include children who can make a claim against a power of attorney for a principal, for an accounting, and expanded it to nursing homes, expanded it to creditors, expanded it to spouses. So there's been this expansion in the general obligations law of parties who can now do this. But if a party is deceased and the power of attorney ceases upon death, there is nobody in a legal position to defend the personal financial records of the decedent. And we all know how important that is, because personal financial records of a decedent can really be personal stuff. You get somebody's credit card records. You can see where they've been, on what dates and what places, what they spent money on. You get their checkbook. You can see the same thing. Deposits. You can see the sources of all of their income. In this case, what business is that necessarily of a nursing home, of a creditor, of an estranged child, like the case herein? And Gregory Lang, in this case, is estranged, according to the affidavits of his brother and sister. And what about a spouse? Suppose spouses are separated for 20 years, and now all of a sudden, but they're not divorced. Now all of a sudden, a spouse has the right to come, make a petition, and demand the records of the power of attorney. And that's we're saying that somebody has to defend the rights of the estate. In this case, the right of Alice Lang not to have her personal records examined by a son that she had been estranged from for many, many years. Well, the power of attorney, himself or herself, may be in a position to do that, or may not be in a position to do that. That power of attorney has been kind enough to be the power of attorney and perform their function, but upon death, that function stopped. So that person has no legal authority to say no necessarily to a request. In addition, what's their incentive to say no at this point in time? Who's going to even tell them that they have the opportunity to represent the estate? And they don't represent the estate. And their position, their interests may not be aligned with that of the estate itself. So we've got this situation where who's going to pay the attorney for the power of attorney to come to court and defend on this? So what does the petition look like in this case? The petition looks like a petition to get records from Alice Lang. But no legal entity out there. So now you go to court, and this is what they did in the surrogate's court below. And they got an order to serve an order to show cause upon interested parties, whoever they may be. Who knows what those interested parties are, but in this case, it was determined, I guess, that the power of attorney, being one of the children, and the other two children were interested parties. But what is the obligation of an interested party to defend the records or defend the records of the estate? The estate, Alice Lang, needs somebody in place in order to defend this if they want to, or in order just to request the court below to redact some of the information. Let's have an in-camera examination of the records so that we can determine what there is that you can give to this requester and what there is that you don't have to give to the requester. Again, the requester might be a nursing home, might be a creditor, might be anybody out there. It could be a creditor without a judgment.
Counsel, we recognize the argument you're making. Is there anything further?
I'm sorry, Art?
We recognize that argument. Is there anything further?
Just a few things. It's been argued that the petition process itself can protect the estate, but that's just not so, because the petition process just deals with interested people. This is also, it's also been argued that this is a new issue on appeal, and we don't believe this is a new issue. The surrogate in the court below on his first decision indicates that the petitioner should be going to surrogate's court and get somebody appointed to represent the estate. Upon re-argument, the surrogate again says somebody should be going to surrogate's court to get somebody appointed, but they won't do it, and they didn't do it. They didn't do it initially. They didn't do it when the surrogate made that suggestion the second time, the first time, or the second time, or in the time period between that and the present. They just won't go to court and ask for an estate representative to be appointed. We don't know why. I have ideas why that might be, but they won't tell us why that is, that they're so against having an estate appointed to represent Alice Lang. And the last point I want to make here is that there really is no basis for the demands. There's a court decision in Sheldon versus Silver out of Nassau County, which indicates that in order to force a power of attorney to account, you have to make at least some showing of wrongdoing that goes beyond speculation, innuendo, and supposed malfeasance. In this case, they've alleged that my client used the power of attorney to self-deal. My client used the power of attorney to dispose of the mother's assets. My client used the power of attorney when she knew her mother was not sophisticated, that she was susceptible to deception, and that she lacked capacity. All of these things are not true. The other children deny that this was the situation, and that this is amounted to a pure and unadulterated fishing expedition. At least one court has held that, wait a minute, you got to at least make some sort of showing that this isn't just a fishing expedition, that you've got some basis for asking for these things. And so far, no basis had been shown in the court below.
The counsel, how
Sure.
are you going to know if you have a basis if you don't ask for it?
Well, and that's a good point. And that's why I think the showing is probably something very low. That you suspect something because of something, or you have some suspicions because of something. But here, there just has been no showing.
But why should you have to make any showing? How are you going to know if anything was wrong unless you ask, unless you inquire?
And again, what we're arguing is that should be supervised by the court, and they can only be supervised by the court if there is a personal representative appointed who can defend the case, who can be on the other side of it, asking the court for that in-camera look, for that redaction, for, or saying you can't get the records at all because there is no showing whatsoever that there's been wrongdoing. And in this case, it's interesting because Alice Lang, there was a trust, and Your Honor, you had asked about the trust. The trust had the bulk of all the assets in that it owned the house and owned the business and the proceeds from the house and the business. The trust has been distributed. I take that back. The trust may not have been distributed yet, but there's been no question as to the distribution of the trust at this point. Alice Lang was represented by a very competent elder law attorney in David Fenster, and he has supplied numerous records from the trust, and I believe also personal records too of her finances, which have not satisfied the requesters so far.
Counsel, I'm going to ask that you wrap up.
Sure. In conclusion, Your Honor, we ask that a personal representative be appointed for the estate of Alice Lang, who can therefore oppose these requests. Matter of Sawkins notwithstanding. In that particular case, which was just decided in June by this court, I'd like to point out that there was an estate in place at that time, that Danielle and Daniel Sawkins had been appointed as administrators of the estate at the time those requests were made.
Thank you, counsel.
Thank you.
Case 629, Berry versus Preferred Mutual Insurance Company.
Hello,
Yes, Mr. Longstreet, can you hear us?
I can. Can you hear me?
We can hear you. You're kind of in a bit of a haze on our video, but we can certainly hear you.
Let me turn the lights on.
All right. Counsel Tapley, can you hear us?
Perfectly, Your Honor, and hopefully you can hear me as well.
We can. Very good. All right, that's certainly, oh, that's much better, counsel. All right, please proceed.
May it please the court, I'll get right to the point here. This is an insurance case. It's our position that the lower court wrongly granted summary judgment to the insurance company Preferred Mutual. Kind of an unusual posture in terms of the motion that was made. The motion was basically to nullify the policy from inception to 2012. There was nothing in the motion about the current occupancy during the policy term that.
Counsel, I'm going to ask you to do me a favor if you can. When you rock back and move away from the microphone, I won't speak for anybody else. I'm having trouble hearing you. You're breaking up a little bit. So if you could kind of stay still over the microphone, that'd be helpful to us.
Thank you. The motion below did not deal with the current occupancy of the property at the time of the loss during the policy period that was in effect. The lower court did not grant the defendant what it sought, which was voiding the policy from inception, but instead went off on a different issue having to do with the definition of business. The court found that there was no dispute that business was taking place at the property, and we submit that the court just missed the point. It was raised in our papers below. The point is whether rental to a relative who did not pay market rent was a transaction that could be viewed as something not usually viewed as business in nature. That wasn't raised by Preferred Mutual in the papers. It wasn't addressed by the court. It was in our responding papers. It has finally been raised by Preferred Mutual in its respondent's brief, although very cursively. And we submit that the court erred. that there is coverage here, that there's a question of fact as to whether or not the tenant at the time of the incident could be viewed as an occupant that wasn't occupying as a business transaction, but was a family member. Other than that, I don't have any more. Unless there are questions, I'll rely my brief for the remainder.
No questions, counsel. Thank you. Mr. Tapley?
Thank you, Your Honor, and may it please the court, Attorney Timothy Tapley for the Respondent Preferred Mutual Insurance Company. Thank you for your time today and for your attention to this matter. Certainly will address things briefly. However, Your Honors, there are a certain number of factual predicates that create the lens through which I believe we must view this matter. Primarily, Preferred Mutual Insurance Company insured the home of the Barneys at 56 Mason Road in the town of Mexico, and they insured that home and that piece of property alone. When the policy application was submitted by the Barneys through their agent, the agency.
Well, counsel, not to interrupt you, they also, part of the policy included the pole barn, correct?
It did, Your Honor. Yes, Your Honor.
And they weren't residing in the pole barn, were they?
They were not residing in the pole barn.
Would you consider, does the policy contemplate, because it's listed in the policy, that that's a related private structure related to the residence?
The pole barn is included as an insured piece of property on that 56 Mason Road because it was specifically identified in the policy application. A photograph was included of it in the policy application, and it resides on the same piece of property, 56.
And the mobile home does not?
It does not, Your Honor.
It's not listed in the policy, and it's got a different address?
It does, correct, Your Honor.
And it's not occupied by the insured?
It was certainly not occupied by the insured, Your Honor. It also has its own set utilities and set up entirely differently. It had been occupied very briefly by I believe it's Mr. Barney's mother before her unfortunate passing a number of years ago. It was then occupied by a number of different tenants. The Barneys were not able to identify which tenants, all of them that did occupy it, but they confirmed in his affidavit, which is on the record, that he charged rent to all of those various people. What is not on the record is the amount of rent he charged to the various tenants, nor is in the record the amount that he charged to his, I believe it's his niece or his cousin, Skylene, who was the tenant at the time of the fire in September of 2022. Counsel presents the argument that they were charging a below market rate to that particular tenant, a relative at the time of the fire. However, there is no evidence before the court as to the actual amount that was charged to the relative or what the market rate was.
Mr. Tapley, in a way, just getting back to the presiding justice's questions, the pole barn is listed, the residence is listed, this mobile home, which was clearly a separate property that had its own address on a road that was separate and apart from Mason Road, wasn't listed on the declarations at all. And Supreme Court identified that seemingly, I think, as its primary basis for saying there's no coverage because it's not on the policy. And so the amount of the rent and all that goes down the business thing. But I thought your first point was essentially that it's just not there. It's a separate, I mean, that's a very livable, large mobile home. It's not going anywhere, presumably. And it faces a different property. It's got its own utilities. And yet, even though they put the pole barn on, they didn't put this on. And I thought that was your essential argument. If I have that wrong, please go on.
Your Honor, that is our argument. But however, because whether or not this renting of this mobile home, which to your point was not necessarily mobile, it hadn't moved in decades, whether or not that fell within as a business or met the exception to the exclusion, those are parts raised by counsel. So I simply wanted to address those. If the court does not need to hear me address those, I certainly do not need to do so.
It's your call, counsel.
All right. Then just briefly, Your Honor, with respect to the business use itself, there is no doubt that the Barneys, the insureds, collected rent both from all of the tenants, including the relative that was living there at the time. Whether they collected more or less rent might make it more or less profitable, but it does not make it anything but a business in of itself. In fact, Mr. Barney admitted that they took the rent and they applied it to the taxes and the insurance on all their property. So just the fact that the cash didn't go into a bank account but went to pay off other debts doesn't mean that it's not a business. And then lastly, Your Honor, again, attempting to keep it brief, counsel raises for the first time this issue of it being a lower rent. However, there are two cases that coming out of South Dakota that have specifically addressed that issue. I would ask the court just to consider American Commerce Insurance Company versus Few out of the U.S. District Court for the Northern District of Oklahoma, as well as Western National Mutual Insurance Company versus Decker out of the Supreme Court of South Dakota, in which those courts analyzed the exact policy language we're looking at here. In those cases, it was in the context of the insured having a childcare business on their property. And in both scenarios, the court found that a business was being conducted. The opposing position was that, well, in one case, they charged a lower fee to one particular family. In the other case, they said they only charged them some of the time. In both those cases, Your Honor, the court found that just because you charge a little bit less or you only charge a few times doesn't mean it's anything but a business. Furthermore, to counsel's point in their brief that the subsequent language, the exclusion to the exception, being ambiguous, those courts both looked at that exact language and found that there was no ambiguity whatsoever. So I would submit to Your Honors that in this case, number one, there is no coverage because this piece of property, this mobile home, was never contemplated by Preferred Mutual Insurance Company. There's no evidence that they had any knowledge of it even existing, and it wasn't identified in the policy. If somehow we got beyond that point, the business use exclusion most definitely applies here, Your Honor, and there is nothing ambiguous about the language.
Thank you, counsel.
Thank you, Your Honors.
Case 630 Cotton versus PEMS Tool and Machine, Inc.
Good morning, Your Honors.
Mr. Platek, can you hear us?
I can hear you.
Very good. The appellant has submitted, is my understanding. If you'd wish to be heard, please proceed.
Your Honors, I will rest on the briefs. Thank you.
Very good. Thank you, counsel. Cases 631 and 632, Bush versus County of Lewis. Mr. Sarando, please proceed.
Thank you, Your Honor. John Sarando, excuse me, on behalf of the appellant.
Mr. Sarando, just for what it's worth, I believe, as I'm looking at some water in front of the podium there, that you're more than welcome to use if you need.
Excuse me.
Sure.
Hopefully that's better. This is an appeal from a denial of dismissal of a lawsuit involving, I think the crux of the matter is the notice of claim and the date that everything should start. And this is an unusual case in the sense that there is no or should be no claim of prejudice because the detailed letter that counsel sent to the facility and the discussions counsel had with the insurance adjuster and the furnishing of all of the medical records that would be involved in the matter obviates any claim of lateness or prejudice.
And counsel, you're making reference, I believe, and correct me if I'm wrong, to the November 9th, 2023 demand letter. Very good. Okay,
yes.
Proceed.
And we submit that the court also utilized the wrong date or incorrect date for the beginning of the clock. We submit that it should be, when you look at the complete, what happened, the date of death, November 17 of 22, which makes everything timely, we submit. And the reasonable excuse, I think the reasonable excuse is they gave everything to them and they were lulled into a false sense of security by the actions of the carrier and the entity as to what was going on with the case.
Well, we have a date of death, I believe, of November 17th, 2022.
Yes.
And then we have defendants sending an email to the plaintiff stating that acknowledging that the hospital was a municipal hospital and owned by Lewis County, and a notice of claim was required. But that wasn't sent out until January 17th, 2024. So those are the timeframes we're dealing with, correct?
I think that was later. I thought their letter was sometime in February.
All right, well, I'll check the record, but my notes indicate January 17th. I could be wrong. But plaintiff sent a notice of claim that very day, claiming damages arose and also claiming the wrongful death arising on 11/17. But I'll check the dates on that.
January 17th was when we sent it out. February 2nd, they rejected it. That's my understanding.
Oh, when they rejected it. Yeah, that's
Yes.
a different date, February 2nd. I'm just talking about when notice
January
was,
17th.
when you were advised that of the municipal corporation and a requirement of a notice of claim.
They did it that same day.
Yeah.
Yes.
Okay.
So we submit that.
But that's the time frame that we're dealing with in terms of the lapse of time from the date of death until there was a notice of claim that was sent in the same day they received an indication that they were required to file one.
Right.
And you're saying that the time lapse in between, there was kind of false sense of security because there seemed to be some exchange of information and some reliance.
A lot of reliance, yes.
Okay.
And
we'll take a look at that, Council.
yes, and I think the correct date to starting date is November 17th, 2022, when everything happened, when the lady died. And everything that was done up until that point culminated in her demise. And I don't know if we need to get into the renewal argument, but if we do, the new fact is that the court came up with November or September 26th as the optimum date, and in its first decision, and we submit that the correct date should have been November 17th.
As opposed to when the decedent was discharged and sent to the hospital for rehab?
She came back from. I'm
trying to figure out what other date you're.
November 17th, the date she died.
Yeah, no, I understand that's the date.
And
the
court went off on the first decision with September 26th when she fell out of bed.
Right, okay.
And we submit that when you look at the death certificate and the everything.
We'll take a look at that.
It all flows from that.
Mm-hmm.
And even when she went back to Lewis County facility, she was still, they didn't treat her correctly, which then led to her demise at the hospital.
We'll take a look at that.
Yes, and so we submit that the biggest thing, Your Honor, and I know you'll take a look at this also, is the fact that there's absolutely no prejudice to the entity.
Because of the early notice with respect to the letter.
Because
the demand letter.
Yeah, and what they submitted with it. I think there's a Court of Appeals case where they indicated that, that type.
Well, there was a demand letter. Do I understand? There's a demand letter And then there's a request from them for information materials, which was supplied. And
This-
that was done in a relatively timely fashion.
That was the same month.
Right.
Yes, yes.
Okay, so that's what the two things combined result in no prejudice.
Right. And I think that the Court of Appeals said something about the furnishing of the medical records. They have to be tied in with the claim and what you're telling them. And I think this does mirror into that to allow that to justify the reinstatement of the lawsuit.
Very good. Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the court. Corey Schoonmaker from Sugarman Law Firm on behalf of Lewis County. Petitioner, both before the trial court and on appeal, appears to conflate the two aspects of their claim in order to rely on the wrongful death statute of limitations. It is important for the purposes of these two appeals that there are, in fact, two separate claims being made here. There is the wrongful death cause of action, and there are the claims based on conscious pain and suffering, the personal injury, medical malpractice claims that are also being made on behalf of the deceased. These two claims track on different timelines, which has given rise to the sort of procedural complexities that arose below. In appeal number one, the issue concerns whether the personal injury claims were timely at the time that petitioner made their application for leave. They were not. The continuous treatment doctrine extends the accrual date of a medical malpractice claim to the last date of treatment by the defendant. In this instance, it was September 30th of 2022, which was the date on which the decedent was transferred out of Lewis County Medical Center and was never returned to any facility connected to it. There is no basis in the law for the treatment performed at other facilities to extend that deadline to the date of her death, nor does the allegation of proximate cause.
So keeping the focus solely on the personal injury aspect of this and not the wrongful death, and assuming we agree with you that the continuation of medical care ended on the 30th of September, what's the date at which the notice of claim could have been filed?
That would have been December 29th of 2022, which is 90 days after the discharge was the notice of claim. And then a year and 90 days after that was December 29th of 2023, when the statute of limitations for those claims expired. After that time, Supreme Court had no discretion to grant leave because the claim itself was subject to dismissal under.
Not just beyond the 90 days, but beyond the year and 90 days.
Correct. Yes, Your Honor, because the application was made in February of 2024, a little over a month after the statute of limitations had expired on the personal injury claim.
And your argument is that was a right determination by the court below?
Correct. Yes.
And that ends the discussion with respect to the pain and suffering claim.
Yes, the decision order as appealed in appeal number one should be affirmed for that reason.
Now the wrongful death.
Yes, so the wrongful death claim ended up being a little confusing below because there was an incorrect date of the petitioner's appointment as a state representative in the first motion that was made. It was subsequently discovered that the date of his appointment was in December of 2022. It was December 23rd of 2022. He was given unrestricted letters testamentary, but that was not made known to the court or to our office until after the initial motion had been decided. So we made our motion to renew on the basis of that new evidence. I don't believe the procedural sufficiency of our motion to renew was objected to in the appellate papers. So I'll just gloss over that unless there are any questions about it. But the basis was the newly discovered date at which he was appointed. Based on that date, the 90 days had elapsed. The initial 90-day period to serve a notice of claim had elapsed by March of 2023. The statute of limitations
for the wrongful death claim would have been 2 years from the date of death, which had not expired when the motion for leave was made. Thus, the Supreme Court was required to make an analysis of the factors in the general municipal law for leave. The court did not make an analysis of those factors in the initial motion because based on the represented date of appointment in the first motion, we were still within the 90 days. And so the court said, I don't need to analyze that. So based on the facts that they believed originally, that would have been correct. However, there was an analysis necessary for the general municipal law factors once the true date was discovered. It was in this respect that Supreme Court erred. From the decision in order, there is no discussion of any of the factors that were that needed to be considered as part of this analysis. That is not to say the court did not consider them. I recognize that the full reasoning may not have made it into the final decision in order, but even if it had been considered, Supreme Court did not render the correct decision on those issues. The key factors for this analysis would have been reasonable excuse for the delay in bringing the application, actual notice to the defendant or the respondent in this case of the essential facts of the claim within 90 days of its occurrence or a reasonable time thereafter, and some evidence or plausible argument that the respondent would not be prejudiced. The prejudice issue, which is the primary focus of petitioner on appeal and was a primary focus below, should not be the primary focus of this court. That is because, as set forth in the cases that we discussed in our papers, the absence of a reasonable excuse or actual notice within a reasonable time, if neither of those factors are present, then it is an abuse of discretion to grant leave, even if there is no prejudice. The excuse that was given, both below and on appeal, is essentially that there was a demand letter sent in November of 2023. There has been no offer of any excuse, reasonable or otherwise, between the date of appointment in December of 2022 and the letter in November of 2023. There is no explanation for that delay in taking any action, it seems, with respect to this claim. So just based on that period of 11 months of no excuse, we would say that we would argue there's no reasonable excuse given for the entirety of the delay because a large portion is unaccounted for. Even if the notice was not, the letter that was sent was not, was reasonable from that point forward, we would say that we argue that the formulation that the petitioner has given for what happened between them and the insurance adjuster is not accurate. Respondent's insurance adjuster informed petitioner that there was an investigation ongoing. That was not false. That was not misleading. At no time did anyone representing the respondent indicate that the case was definitely going to settle. There's no reason to bring a claim. There's no reason to send a notice of claim. In order to establish some wrongdoing on the part of the insurance carrier or the party, there would have to be some duty to inform the petitioner of their obligations. I would rely on the Ippolito v. City of Buffalo decision, in which there was noted no obligation to warn the opposing litigant about the untimeliness of service of a notice of claim, even when there was pre-action discovery that was participated in fully by the respondent. They were still not required to indicate, hey, you need to do this.
We'll look at that, counsel.
With respect to actual knowledge, the actual knowledge must be obtained within a reasonable time after the expiration of the 90 days. Here, 9 months-ish elapsed between the expiration of the 90 days and that November 2023 letter. We would say that as a matter of law, that is not a reasonable time for the reasons cited in our papers. And with respect to prejudice, I would just note that the initial burden on the prejudice element is on the movement, who must, as I mentioned before, establish some evidence or plausible argument that there is no prejudice from the delay. And in this case, the argument was only, it's difficult to see how they were prejudiced. That wasn't the prelude to a more detailed discussion, that was the entire argument. And so we read that as in an improper burden shifting, trying to place the initial burden to get rid of the prejudice on us. I would then point out that there more than 13 months had gone by at that point since the treatment at issue in this case. Thank you.
Thank you, counsel.